Welcome back to Canadian Justice, where we're discussing a recent Supreme Court decision that found that the Impact Assessment Act, also sometimes called the No More Pipelines Law, is unconstitutional. Now, Aidan, one of the most contentious parts of this legislation is that once a project is on that designated list, subject to review by the federal government, it goes through this years-long process where different impacts are considered. And the list of impacts is exceedingly wide-ranging, and it includes economic, social, health, environmental, and even gender-related impacts. What can you say about that and what the Supreme Court said about that?
So it's important to distinguish between the impacts that are considered when the assessment agency is putting together a report and then the factors that are considered by the minister in the final determination. At the assessment stage, it considers a wide range of factors: the need for the project, alternatives to the project, the intersection of sex, gender, and identity factors. And the majority was of the view that the breadth of those factors was not in and of itself problematic, but they spoke to the fact that the act as a whole was not clearly focused or targeted on adverse federal effects. And then there were another range of factors, including things like sustainability, that informed the minister's ultimate decision. Ultimately, that was the part of the act, that decision making authority or potentially a veto authority, that the majority found to be unconstitutional and clearly or plainly overstepping the federal government's legislative area.
Now, Gerard, the federal government claimed to have the authority to regulate so broadly on the basis of sections of the Constitution Act 1867 that gives Ottawa the power to regulate Indians and Indian lands, which is a term from the Constitution. It gives them the power to regulate the seacoast and inland fisheries and to regulate for the peace, order, and good government of Canada. This is called the POG power. And what did the Supreme Court say about that? Are these provisions in the Constitution enough to bring these projects entirely within federal jurisdiction, even if it's wholly within provincial territory?
The answer is no, but it depends. Why depends a little bit differently for each of the powers. Regarding the power concerning Indians and land reserved for Indians, as well as the power concerning seacoast and fisheries. The problem with the act was that once a project fell within the scope of the act, the federal government was permitted to engage in considerations in deciding whether or not and on what terms to approve a project above and beyond what would be relevant to, for example, protecting Indigenous rights or protecting fisheries in and of itself. And by extending beyond that and clearly entering provincial jurisdiction, the act was constitutionally problematic. Regarding POG, that is that's a residual power that the federal government that has to be applied in very narrow and strict circumstances for discrete matters that truly cannot be dealt with by a province. And given the breadth of what was at stake here, Chief Justice Wagner simply held that it can't fall within the standard for POG.
Aidan, is there anything you want to add to that, in particular on this issue of the POG power?
The POG power is certainly interesting because it was the basis with which the GHG backstop in the GGPPA reference was upheld.
Yeah,
But
for people
there,
not familiar with it, that's the greenhouse gas emission pricing reference to the Supreme Court. Sometimes people refer to that as the carbon tax case. For the
and in that
national
case,
minimum standards for carbon emission regulation.
precisely. And the by establishing national minimum standards in that case, it was a distinct regulatory mechanism that did not give the federal government broad and unfettered discretionary power in areas of provincial jurisdiction, which stands in stark contrast to what exists here. Basically, what happens is that if a project came into the designated side of the IAA, once it had been designated and subjected to that assessment, the federal government had what the majority described as untrammeled power to regulate the project. And it's notable that the majority, in fact, characterized Canada's attempts to uphold this part of the IAA under the POG power as an attempt to do a, quote, end run around the court's recent jurisprudence in the carbon tax reference.
You know, I think the carbon tax case is really an interesting one because I think it's this issue of national minimum standards. A lot of people had a lot of concerns when POG was used in that case, that this would result in this bleeding of provincial jurisdiction on things that could sort of cross-provincial borders. And I think that that's one of the responses to this decision is, any project, even within provincial borders, can cause greenhouse gas emissions. So there's this question of why the court reached a different conclusion. I want to dig deeper into that sort of crux of that issue when we come back from commercial break.